Thank you for participating in the State Bar's mentoring program. My name is Aviva Kaiser. I am one of the ethics counsels here at the State Bar, and I will be discussing with you some of the major ethical issues that can occur in a mentoring relationship. So we have three main areas of concerns for the mentees. First one, does that mentee need client consent to disclose information to the mentor to discuss certain issues? The second one is, what steps can a mentee take to preserve the information of that client? And three, what steps can a mentee take to avoid creating a conflict of interest? So are you ready? We're going to get started. I thought that what we would do is look at a hypothetical situation to help us explore those issues. So here's our situation. We have a mentee who's been retained to represent two co-personal representatives in what appears to be a really straightforward probate case. So nothing difficult, right? So one of the assets of that estate is a personal injury case, and the mentee thought that that would be just what damages occurred for the decedent. But about 3 months into the representation, our mentee learns from the lawyer who represented the personal injury case that the settlement was a lump sum settlement. It didn't allocate the damages between the damages to the decedent or the loss of companionship for that decedent's spouse, which did not belong to the estate. So now we have the two co-personal representatives. They're disagreeing about how that settlement should be distributed, and the mentee would like to ask the mentor for advice. When we get into this situation, there are two issues that are presented. Number one is the ethical issue, and that is, can the mentee ask the mentor about the conflict of interest that may occur between jointly represented clients? And the second one is the underlying substantive issue, the legal issue of allocating that lump sum settlement. So, as with any ethics, we're going to start with the rules. We want to start our analysis with the acknowledgement that there is no general exemption in the confidentiality rules for lawyers participating in mentorship programs. In other words, the rules do not mention mentorship programs at all, nor do they really talk about consulting lawyers and consulted lawyers. So whether a mentee or a lawyer consulting with another lawyer must seek that advance consent from the client is in some ways an open question. So we're going to talk about that. Now, first I want to talk about Rule 1.6, our confidentiality rule. If you notice from the rule, you could never find a broader rule than this. It prohibits a lawyer from revealing information relating to the representation of the client. That's all information, not just some, but all information. It even covers client identity, and it covers information regardless of where the source of that information is. So lawyer can read something in a newspaper. Lawyer can hear something from someone else on the street. That's information that's covered by 1.6a. So there are two relevant exceptions. In other words, lawyers must not reveal any information relating to the representation of the client without the client's consent, or if it fits within some limited exceptions. So there are two relevant exceptions we're going to talk about today. The first one is the impliedly authorized exception. That appears in the main part of the rule, 1.6a. Now, generally speaking, because I'm belt and suspenders as far as ethics goes, I don't really like to rely on that impliedly authorized exception, but it is one of the major exceptions we'll talk about today. And the second exception we'll talk about today is under 1.6c3, and that exception allows a lawyer to reveal information, and notice that language, to the extent reasonably necessary to secure legal advice about the lawyer's conduct under the rules of professional conduct. So if I have an ethical question, I am permitted by the rule to talk to another lawyer about it, but I can only reveal as much information as reasonably necessary to get advice. So under our hypothetical, the mentee is permitted to talk to the mentor and to reveal information under 1.6c3 to the extent reasonably necessary for the mentee to get advice about representing those two co-personal representatives who may disagree right now. So consequently, mentee may ask the mentor about that conflict of interest between those two jointly represented clients, and no client consent is necessary for that. But while we know that the mentee doesn't have to ask client consent or obtain client consent on the ethic issue, the question of whether there's client consent needed to discuss that underlying substantive issue is not settled. So while there's several resources that I have for you that will indicate that the consulting lawyer or our mentee is impliedly authorized, remember that exception, and the client consent is not needed, there's no Wisconsin case law. We have no ethics opinions, we have no court opinions, and our rule doesn't address it. So to that extent, I say that, it's unsettled. There is, however, a really well-respected treatise in ethics law, and it's the Law of Lawyering. And you'll notice here that the Law of Lawyering does conclude that a lawyer may make those disclosures under the impliedly authorized exception when the consultation is needed in furtherance of the representation. And again, that's the impliedly authorized exception. It's echoed in the Restatement of Law Governing Lawyers, another really important resource we use. The exception here is that the lawyer cannot reveal information that would be either violating the attorney-client privilege or would somehow disadvantage the client. But again, we find that in this restatement provision, the reporter's notes actually mentions an older ABA opinion. And I provided that cite for you. It's 98-411. And once again, that opinion says that a lawyer has that implied authorization to reveal information when they're trying to secure advice. This opinion does put some limits on what information can be disclosed. The information that cannot be disclosed without consent is information that's protected by the attorney-client privilege or information that would otherwise be prejudicial to the client. This older opinion is actually based on the prior rules of professional conduct. So if you ever are familiar with the Model Code of Professional Responsibility, the old confidentiality rule protected clients' confidences and secrets. It wasn't as broad as our new rule, and confidences was attorney-client privilege material, and secrets was information that would be prejudicial to the client or embarrassing to the client. So this older opinion really reflected the prior law. So one of the things the mentee would consider is whether the information is protected by the attorney-client privilege. If it is, I would never disclose that information in that consultation. And again, keep in mind, attorney-client privilege is so limited. I provided the cite there, but it is so limited compared to our confidentiality rule. So our answer to this one is whether the mentee must obtain client consent to talk about the underlying legal issue, the allocation of the lump sum. It's not clear. My advice is there's no Wisconsin authority. We have the other persuasive authority, but I think the mentee would be safe revealing information that is general, that doesn't reveal attorney-client privileged information and wouldn't be prejudicial. And again, if the mentee is going to reveal more information, in other words, information that is protected by attorney-client privilege or information that would be prejudicial, that the mentee should secure that client's consent, informed consent. Informed consent is defined in Wisconsin under 1.0F, and there, to obtain that informed consent, the mentee must tell the client adequate information about all the risks involved and then the reasonably available alternatives. And when I talk about the risks involved, here it would be the waiver of the attorney-client privilege. It might be even that information that would prejudice the client, that would not be discoverable later, that would be revealed. So the mentee should give that some serious consideration before talking to the client about it. So we've talked about now whether the mentee needs to get client consent to talk to the mentor. But now I want to talk about what steps that mentee can take to secure that confidential information. As I noted, that because that mentor-mentoring relationship is not a client-lawyer relationship, and the two lawyers are not in the same firm, then the mentor has no duty of confidentiality. So the mentor basically can disclose that information that the mentee tells the mentor. What the ABA opinion recommends is that you use hypotheticals or general descriptions when at all possible. And notice in our scenario, we did that. What did we say? We said we had a lump sum settlement, right? We said that the settlement itself didn't allocate the damages between what was owed the decedent and what was owed under the claim of loss of companionship. And that's general information. The ABA comment that follows, Rule 1.6, suggests that you do the same thing. It says a lawyer's use of a hypothetical to discuss those issues relating to the representation is permissible as long as there's no likelihood that the listener will be able to identify the client or the situation. So our mentee, even in those situations of permissible disclosure, would still have to take steps to protect information. So even when we can disclose information, we want to be really cautious that we protect confidentiality. So one of the ways the mentee can do that is to ask the mentor for a promise of confidentiality. Now, we're not talking today about the legal enforceability of that because it's beyond this, but at least it shows that the mentee made a good faith effort to protect that information. One of the things I want to tell you today, because it's a new rule, is in the past, because client identity is protected by confidentiality, if there was a conflict, it was often hard to detect it or resolve it because you couldn't provide identity. So for example, if I had a client and I wanted to find out if there was going to be a conflict, I couldn't say to the other lawyer, well, who do you represent? Because that was protected. He would go to his client and say, Aviva wants to know if I can disclose your identity. And of course their client would say, well, who does she represent? And then my client would say, well, who do they represent? So we could often never disclose or either detect or resolve those conflicts. So as of January 1st this year, our confidentiality rule is amended to read that a lawyer may disclose information to detect and resolve conflicts, as long as that information would not compromise attorney-client privilege or otherwise prejudice the client. Notice that's the very same language that's used in determining whether you would need client consent to disclose information. Our paragraph 6C does differ from the model rule. The model rule, which is in B7, is limited to lawyers who are either changing jobs, or if the law firm is changing its composition, so if there's mergers in law firms, or if lawyers are moving from one firm to another. So the model rule is limited to that. Our rule is not. We can disclose that information to detect and resolve conflicts even within the same firm. So one of the things that's exciting about the mentorship program, if we're concerned about mentors having a conflict of interest, mentees can, under this particular rule, disclose the identity of the clients as long as it wouldn't, risk prejudicing the client. In terms of what it means to prejudice the client, there are some examples of that in paragraph 13 of the ABA comment. And if you notice here, it generally happens in the kinds of cases where, for example, corporate takeovers, where the identity itself would give a hint to something that may be happening, or in divorce cases where the spouse doesn't know yet. So we've talked about ways we can protect that client information. What I'd also like to talk now about is the conflicts of interest. So again, because the mentee is not retaining that mentor, there's no issue of conflicts as we normally think of it, but we still need to be mindful of it. Conflicts basically protects information. So revealing that information that's protected by confidentiality can create a serious problem for both the mentor and the mentee. But we'll concentrate for the mentee right now. Mentees generally want to avoid talking to a lawyer who has represented adversaries in the past on matters, or maybe representing adversaries in future matters. And especially in those smaller legal communities, there is a real possibility that there would be future adversity. And we'll have a hypothetical about that. But one of the things we want to be cautious of is that if you have a mentor that's in the same area of practice as the mentee, then there may be more possibilities for conflicts. So let's talk about the issues for the mentor now. Again, two areas of concern: confidentiality and conflicts of interest. So we're going to continue with our scenario from the mentees. And so now we'll have our mentor say, yes, I can help you with that. So we have our mentor. The mentee provided the mentor with names of the two co-personal representatives to make sure that the mentor did not currently represent them or had not represented them in the past. And again, that's permitted by 1.6C6. The mentor provided the mentee with advice about the conflict of interest involving the two co-personal representatives, as permitted again by 1.6C3, so everything was fine there. The mentor also provided the mentee with advice about the underlying substantive legal issue, that allocation of the lump sum. In fact, the mentor also provided the mentee with the name of an expert who had helped the mentor in the past on a similar issue. But it gets a bit more complicated. Several days later, the mentor's law partner has an initial consultation with a new client. New client comes in, new client says, I'm a co-personal representative in an estate. I disagree with my other co-personal representative about a lump sum settlement and the allocation of it. So the mentor's law partner does what we generally do, obtains enough information to do a conflicts check. The law partner checks the law firm's database, finds no conflict, and then begins to work on the case. About a week later, the mentor learns that his law partner is now representing one of the co-personal representatives, both in the official fiduciary capacity as well as in that co-personal representative's individual capacity. And the mentor learns this when his law partner asks him for advice about the allocation of a lump sum settlement. The mentor had not entered the names of the co-personal representatives in the law firm's database, so his partner would not have known that the mentor had talked to the mentee about it. Again, if we look at confidentiality, because the mentor normally does not represent either a mentee or the mentee's client, then that mentor does not owe a duty of confidentiality under 1.6. If you recall, that ABA opinion, 98.411, took the position that a mentor does not in fact owe the duty that a mentee or that a lawyer would normally owe a prospective client, which is a more limited duty, but again, no duty there. So what that prudent mentee should do is request confidentiality from the mentor. And we saw that, again, you can ask for those official promises or formal promises. We don't know what the effect of those are at this point. Again, it's beyond the scope of ethics, but certainly we believe that courts and disciplinary agencies would likely afford those promises great weight. In terms of conflicts of interest, certainly the mentor could not provide an adverse party with advice that's contrary to the interests of that mentor's own client. In our scenario, the mentor did not have the client at the time, but what happened now is that our mentor's law partner has that client, and we risk that because of the imputation within the firm that our actually clients could have a conflict of interest, or our mentor and mentee could have conflicts of interest. So what's the reasonable steps to avoid those conflicts of interest? Our mentor and mentee did a great thing here. They made those efforts to make sure that they were not giving advice at the time to opposing parties. Remember, our mentee did provide the names of the co-representatives. And the ABA opinion gives us a little bit of a safe harbor. Basically, it tells us that if the mentee does not know, or the mentor does not know, and unwittingly gives that advice, then there's no violation of that duty. The problem that we have is that the future conflicts, and here, when the conflicts are based in large part on that duty of confidentiality, on that information where that consultation has taken place, generally speaking, we say no conflict will arise. So what we have now is our mentor has information about the mentee's client, the mentor's partners representing the adverse party. But under the general rules, we say that there's no, that conflict is not going to arise because there was no expectation of confidentiality. But we do have some case law that when there is that consultation, there may be an implied promise of confidentiality. And if there's that implied promise, then there would be a conflict. And I've provided you the name of a case from Wisconsin, Burks versus Hales, that actually does state that there could be that implied attorney-client relationship. So we recommend that the mentor may also wish to ask the mentee for a conflict waiver at the time, and that could be based on screening. So what we would do is say to the mentor, look, if it happens that in the future one of the adverse parties contacts your firm may be able to represent that party, but we would like you to be screened from that. And again, that's based on the ABA opinion as well. So I want to thank you for participating. I know we went through things really quickly. If you have any questions, please feel free to call the ethics hotline or to call me. My information's there, and I'd be glad to help. Thank you.